Hello and welcome back to Coffee Time with Robbins Appleby. It's quite amazing. We're in our episode 4 and our second part in a 3-part series on bringing employees back to work. So our first part was about what are the employer's obligations to create a safe workspace by creating a generalized policy, and then by addressing individualized accommodation for particular employees. Today what we want to talk about is how to keep COVID-19 out of your workplace. Can you test employees before they come into to work to make sure that your environment is safe? And then in our third episode, we'll address what happens when employees refuse to come to work or refuse to comply with your policies. So I want to say hello to my fellow lawyers from Robbins Appleby. Ismail, how are you?
Pretty good, thanks.
And Charlie, how are you?
How are you, Jonathan?
Nathan, nice to see you.
You as well.
So Nathan, I'm going to start off with you. So we heard in our first part of the series about the generalized policies that employers need to put in place to protect workplaces, and also specific accommodations that employers will need to make for employees of protected groups. But what happens if an employer wants to take steps in order to prevent COVID-19 from coming into their workplace by screening employees before they show up or as they show up to work?
Yeah, so I know personally I've seen a number of instances of people talking about this in the news, or even when you go to stores, sometimes there are stores that are screening patrons. So employers may be considering screening their own employees, and the two dominant methods that I've seen are self-assessment questionnaires and temperature testing. Unfortunately, given testing employees for COVID is obviously a new phenomenon, and there really wouldn't have been a reason for most employers to have conducted health screening prior to COVID. There isn't any case law that is exactly on point. However, the underlying question here is whether an employer can test employees for a condition that may put the safety of other employees or patrons at risk. And for this question, we can look to other contexts where this has been addressed, such as employee drug and alcohol testing, and we can try to pull some parallels from that. So essentially, there are two facets to consider. The first being the parameters of screening, and the second being responding to either a refusal to participate or a positive test. So in terms of the parameters of testing, so long as it is reasonably necessary to protect the safety of the workplace and it is carried out appropriately, screening is likely to be valid and enforceable. However, the appropriateness of testing will be a workplace by workplace assessment, so we can't really provide any broad sweeping generalizations about the validity and enforceability. But in the drug and alcohol testing context, testing has been held to be permissible where there is evidence of a widespread drug and alcohol issue in a safety-sensitive workplace. The hazards caused by that impairment cannot be addressed by less intrusive means, and when conducted, the testing is minimally invasive and privacy is maintained, for example, by the employer storing the data in a secure place, only collecting the information that is necessary to assess the impairment, and retaining that information only for so long as is necessary to address the issue. So in other words, the testing is reasonably required to protect the safety of the workplace, and employers balance the concerns with employee privacy and the right to be free from discrimination.
So that's interesting, Nathan. So about privacy, so employers have obligations to keep test results private for employees?
Yeah, so the laws governing the privacy protections for private sector employees really only exist for employees that are federally regulated or that are in Quebec, Alberta, and British Columbia, where these provinces have privacy legislation. Otherwise, there is no legislation in Ontario, for example, providing privacy rights for private sector employees. And the common law really only provides specific or protections in specific situations, which we actually discussed in our first episode. So viewers may want to refer back to there to see this further. However, there are some privacy concerns in Canada, and privacy concerns are evolving. So employers are well advised to tread cautiously by perhaps adopting the best practices from these jurisdictions with such laws, including developing policies for the use, collection, and disclosure of such information.
So Nathan, you mentioned in the beginning that there are two facets to consider here, the latter being the response to the refusal to participate and positive testing. Can you just talk about the refusal to participate?
Yeah, and the refusal to participate is an important point to consider because it leaves an unknown in the workplace. And so where testing is reasonable, then like in the drug and alcohol testing context, an employer may treat a refusal to participate as a presumptive positive. If the employer can't test the employee, then there is an unknown that the employer may or may not be impaired, and the employer has to sort of err on the side of caution and say they might be impaired and there might be a safety risk, or in this case, there might be a risk of transmission. And courts in Canada have held that an employee may face discipline for failure to provide medical information or knowingly providing inaccurate information, where doing so creates a hazard in the workplace. And the exact disciplinary measures that an employer might take to address this refusal will vary depending on the workplace and the policies that are in place.
Okay, so and Ishmael, do you want to just talk about responding to positive testing?
Sure, Charlie. As we mentioned in our last episode, employers should develop policies to address different situations that may arise. Similarly, employers should develop policies that are addressing testing. This policy should include, if the employer is doing the testing themselves, how and when are they going to do the testing? And what accommodations need to be provided if the screened employee tests positive, whether or not the employee is actually infected or not, if they just test positive. The employers will also want the individual to be sent home to protect others in the workplace. So the policy should address how to get the employee home safely. In the last episode, we talked about the request for accommodation, but employers should also be aware of the employee unpaid leave entitlements, such as the infectious disease emergency leave that was recently introduced in the Employment Standards Act, which applies where an employee cannot perform their work for reasons related to COVID. Employers may also choose to provide sick days specifically for COVID above and beyond regular sick days. This could be used for employees that are undergoing testing or for employees that actually test positive for COVID. Overall, as we've mentioned previously, you want to consider all the scenarios and be well prepared ahead of time, and also be flexible as the scenarios are not going to cover everything.
So what are the best practices for employee screening?
Yeah, so if an employer is going to be screening, we've put together a number of best practices, and these are by no means an exhaustive list, but because employers should consider what their workplace needs in their particular situations, but these are some of the ones that we feel are important. So first, an employer should adopt a clear policy that outlines the testing requirements, the consequences of refusal to participate and failed tests, as well as the use, disclosure, and storage of the information, particularly if there's a legal requirement to do so. Second, the questions in any self-assessment questionnaire should be confined to symptoms and activities that are relevant to potential transmission in order to collect only the information that is necessary to assess the safety issue. Third, the means of testing should be as minimally invasive as possible. So for example, using a infrared temperature scanner as opposed to a traditional thermometer. Fourth, the employer needs to ensure that there's proper training and sanitation for those conducting the testing, both because the people conducting the testing may be the employees themselves, such as human resources staff, and the employer wants to ensure that there are reliable results. So the individuals conducting the test have to be trained accordingly. And finally, the employer wants to develop a accommodation policy for those that yield positive results.
All right, so today we've learned that you actually can test employees to make sure that they're not bringing COVID-19 into your workplace, but you need to use minimally invasive techniques. It's highly contextual, and you need to protect employee privacies. And really the best way to do all of that is to make sure that you have clear and concise policies. This has really been interesting. Now, I'm looking forward to the third part in our series, which is to talk about employees who refuse to come to work or who refuse to comply with the policies. So looking forward to next time, guys. Thanks very much. See you soon.
Thanks, Jonathan.